Hi everyone, and welcome to our fourth session in the A Well-Heeled Life 2020 Financial Education Series for Women. My name is Alessandra and I'm one of the financial advisors in our wealth advisory team at William Buck. What an interesting day we've had today with the latest lockdown announcements. We were so close to being able to hold this event face-to-face in our offices, but unfortunately we are back to webinars. I'm here today with Amalia from MT Lawyers, delivering this session to you from the William Buck Studio one webinar room. Feel free to enter any questions you have in the Q&A section. So today I will cover off topics in relation to aged care, including understanding the costs, the need for advice and aged care in the future. Then Amalia will take over and cover off estate planning. So I'm going to go through some statistics for you. Australia has an ageing population at present. 15% of our population is over the age of 65, which has increased by 6% since the late 1970s. And this is expected to increase by 22% by 2057. 221,000 people commenced using aged care services in 2018-90. And the average stay in residential care is now 2.5 years, which has increased significantly from 6 months a few years ago. Because of all this, it's imperative we have a system in place to assist Australians with varied needs of care. Aged care placement is a huge decision and is often surrounded by a lot of emotion. Coming to terms with the fact that it's time for your loved one to leave their family home and enter a care facility is difficult not only on the individual but on the families. Therefore, people can't be expected to be in their best frames of mind or know exactly what to do when they're clouded by this emotion. So seeking advice from the right people is imperative. So I'm just going to explain the difference between a retirement village and an aged care facility. So a retirement village is different to an aged care facility in that it's more of a lifestyle choice. It connects you with small community. You can access home care through retirement villages, but ultimately they can usually end up in costing a lot, specifically when you're exiting the community in fees. So good consideration from a lifestyle perspective, but potentially from a care perspective, perhaps not the best. Aged care facility houses you and takes care of you medically 24/7. If you're considered low care, you can obtain home care assistance as well. However, if you're considered high care, you will need to consider entering residential care. If you have more assets, your ability to pay is greater and you will pay more, but there are concessions available to those who are low income individuals. So in order to access the government subsidised home care or aged care facility, you will need to be assessed by a member of the aged care assessment team. So the member of the aged care assessment team will be a doctor, nurse, social worker and or other health professional, and they'll meet with you to discuss your care needs and how well you're managing a home. They will identify the right services for you and the level of care you require. The ACAT will give you a letter stating the types of subsidised services you've been approved for and will most likely put you in contact with organisations that can assist you in your area. So we'll go through some of the costs in relation to home care packages. So whether you're a full age pensioner, a part age pensioner or a self-funded retiree, there is a basic daily care fee for the home care packages. The fees range between $9.63 per day and $10.75 per day. The ACAT assessment will determine your level of care from 1 to 4, with 4 being the highest level of care. If you're a part pensioner or a self-funded pensioner, you will be asked to pay an income-tested fee in addition to the basic daily fee. So for a part pensioner, that would be capped at $5,617 per annum, or for a self-funded retiree, that would be capped at $11,234 per annum. Now, those caps count towards one's lifetime cap of $67,409, which is also the means tested care fee cap for for residential aged care, which we will talk about in a moment. But so it's good to know that cap, the fees that you pay towards the income tested fees included in that as well. Now, boards are making it more effective for care to be received at home. Companies like ECH are really supporting this. We recently had an elderly lady who passed away at 95, but she was receiving in-home care for over a decade with various levels of assistance through that time. But it was comfortable for her in the end, and so at-home care really did suit her, which was a good outcome, I guess, overall. Residential aged care. So if you are considered high care, you will be need to go to a residential care facility. The facility ensures basic living needs are met: accommodation, food, cleaning, showering, as well as full-time nursing and medical requirements. There are two types of costs with residential care. There are accommodation fees and ongoing fees. So the accommodation fees can be paid as a refundable accommodation deposit. We call this a RAD, or a daily accommodation payment, also known as a DAP, or you could do a combination of the two. You will only be asked to pay that if you can afford to do so. The ongoing fees are basic daily care fees, which is a fee that everybody needs to pay. A means tested care fee, which again is only payable by those who have the means to be able to afford to do so. Or an extra services care fee, which is applicable if you wish to take on things like hairdressing within the facility, or you might want to receive the newspaper daily. So there's an extra fee for those types of services. So in a bit more detail, the RAD is refundable when the resident leaves the facility, or it's paid to their estate if they've passed away. The RAD is published on the facility's website and is often between about 300 to 600,000, but can be more or less than that. The daily accommodation is essentially the interest payable on any unpaid RAD. So if the individual is assessed as being a RAD payer, so they need to pay that RAD, they could choose not to do it, and they could pay a daily accommodation payment. Essentially, in order to fund a $300,000 or $600,000 fee, one would most likely need to sell their residential home. So it gives them an option to not do that in a hurry, or to consider alternatives in the meantime. The interest payable on the RAD, so the current rate on that is 4.1%, which is significantly higher than what we can all get in the bank at the moment. But it's assuming that the home could otherwise invest the RAD that they would have received from you and potentially receive that as an overall return. So everybody must pay the basic daily fee. So ongoing costs, the basic daily fee is $52.25 per day, or $19,071 per annum, which ends up at about 85% of the age pension. So if somebody is fully supported by the government, most of their pension goes towards paying their daily costs. A means tested care fee is subject to an annual cap and a lifetime cap. So there's that lifetime cap again of $67,409. So once someone maximises that, they won't need to pay that anymore. And their annual cap on that is $28,087. So if somebody is paying a very high fee towards their means tested care fee, they might max out that $28,000 within the first half year and only need to pay that for the first half year, and then after that it won't be payable. And then when their anniversary ticks over again, it might kick in again. So assuming all that individual might actually max out that fee within 3 years. So a means tested care fee is only payable by someone, as mentioned, who can afford to do so. Assets include all investment, and the family home is capped at $171,535 when considering the assets test. Now that number is also the amount of assets somebody can have, and once they've had that, they will then be accessible to pay a means tested care fee. So the accommodation fees will be based on what you can afford. Upon Centrelink, will perform an aged care assessment on your income and assets and advise the facility what you can pay. If one partner remains in the family home, then the home is exempt from assessment. This is where seeking financial advice can be of use, particularly those who might be partially supported by the age pension. The calculation can be complex, and sometimes it's best to have someone investigate this for you. And this could also give you some confidence that Centrelink have calculated everything correctly. Quite often, if some income or asset hasn't been reported properly, we can see people being under or overcharged. Hence, having that expert opinion can be of assistance and provide you with some assurance. So this graph is quite busy, I know, but it shows you the various thresholds with aged care. So if somebody has assets of $50,500 and income of $27,736, they'll be assessed as low means and will only have to pay that basic daily fee. If someone has assets of $171,535 or income accessible at $70,215, they will be asked to pay the accommodation fees or a contribution towards that refundable accommodation deposit, or the DAP option. And essentially, if you have assets in excess of $171,000 and income over that $70,215, you will be assessed as a full fee payer, and you will need to fund the accommodation fees as well as be charged a mean tested care fee. So there's a lot to consider, and those thresholds can be quite, I guess, daunting. And also what happens in between is all very individual and really needs to be calculated in the right way. So when we do these considerations for clients, we usually work with the individual's family, and in many cases it's the children who are usually driving the process. In general, families are concerned about raising that lump sum deposit and wanting to understand their options around either selling their parents' home or renting out the property. They also need to understand if their parent has enough income to maintain the ongoing costs and if investments need to be liquidated. And ultimately, we understand that aged care placement is not only costly and has financial stress, but first and foremost is carrying that emotional stress. So we like to think that we can help provide some assurance, at least financially. So aged care in the future. So the government are considering aged care costs and how we can continue funding this as a country with such an ageing population. The government funded $15.8 billion in aged care costs in 2020. Aged care for an individual costs $250 per day. So if somebody is low means, being a full age pensioner, they will only pay $52.25 towards this. So the rest is being funded by our government. The industry is pushing for at-home care over residential due to this increased costs, and current reports and assessments indicate that aged care assessment will not only be financially assessed, but the level of care required will also be assessed and the costs aligned with this. So if you have two people who have dementia, but one is quite severe and the other is sort of in early stages, they could be assessed from a cost perspective very differently. So it will be an interesting, I think, next few years in this space. So I'm just going to have a look and see if there's been any questions come through. So the question is the family home exempt if a child with a disability lives in the home, or is it only your spouse? And that was from Judith. If the person is dependent on the person entering the facility, and it sounds like in this case that could be, then they are classed as a dependent person, so they can stay in the home. And yes, Judith, it would should remain exempt from any calculation. Would anyone else like to sort of submit any further questions? Okay, well, feel free to add any more if you have any. For now, I'd like to welcome Amalia. Amalia has been at MT Lawyers for over 5 years. She specialises in all aspects of estate and succession law and is responsible for the deceased estates and estate admin side of the practice. There will be a short pause, so please bear with us while Amalia and I swap places.
Thanks very much for tuning in. So what happens if you don't have a will in place? Well, you work hard to accumulate assets during your lifetime, but it's important to ensure that your assets go to your intended beneficiaries in the most cost-effective and efficient manner as possible with the least amount of delays. If you don't have a will in place, then your assets will be distributed in accordance with the rules set out under the legislation. So these are called the rules of intestacy. So I've got a diagram up here on screen so you can see how your assets would be distributed in your own circumstances. A lot of the time people think that if they have a spouse, their spouse would receive their assets when they pass away, which isn't necessarily the case. If you don't have a will in place and you don't have any children, then yes, your spouse will receive your assets. But it will also go equally between your spouses if you have more than one. So a situation where this could happen is where you might be married and then you separate, but don't end up finalizing a divorce. And then, some 5-10 years later, you've got a new de facto partner and then you pass away. So in that case, your assets, because you still haven't divorced, you've got two spouses, so it will go equally between them. So that's normally not what people intend. We had a matter where a husband passed away, leaving behind a wife and 2 young children, aged between 2 and 4 years old. So because he didn't have a will, the wife received the first 100K, the personal items, and 50% of the remaining assets. The children received the other 50%. But because the kids were under 18, their share would be managed by public trustee until they turned 18. So the public trustee take fees and commissions the whole time to do that. Now, I'm not sure if you've dealt with public trustee at all, but a lot of the time people can be a bit disgruntled. Even a couple of days ago, we saw a few cop cars rock up out the front of the public trustee's office and had to extract some people from there. And I find people can be unhappy with public trustee because they never intended for someone other than the family to be looking after their assets. So if you have a will in place, you can remove that concept. So in this particular case, the spouse ended up applying to the court to take over the public trustee and look after the children's share herself, because she was going to do that work for free, and she thought she was better placed to be able to know what the kids would need, and she would do that work for free. So she was ultimately successful with that, but it did take some time to get to that point. In that same situation, public trustee, so the kids had received some business land as part of their share, and public trustee were looking at selling that land, most likely because it was going to be easier for them to manage and for the kids on the kids' behalf as money instead of as land. But that land was vital to the ongoing viability of the husband and wife's business. So it was just fortunate in some sense that the husband had left a life insurance policy to the wife of around $3 million. So she was luckily enough able to use that money to buy out the kids, buy out that land from the kids from public trustee so that she could continue with the business. So you can see some of the issues that can arise with the rules of intestacy. Usually what happens under those rules isn't always what people intend. And just while I'm on this page, sometimes we get people call up to say, if I don't have a will in place, my assets will go to the government, right? But as you can see, that's not necessarily the case. It will only get to that point if you don't have any family left. So if you don't have any parents, siblings, grandparents, aunts, uncles, nephews, nieces, then it might get to that point. So now I'll give you a bit of a background that we usually give to our clients during our estate planning meetings. So essentially your assets can fall into 3 pots. You've got your personal assets, assets in super, and you could have assets in family trusts. They can't go anywhere else. Your will deals with your personal assets. So that's anything that ends up in your own name at the end of the day. So that could be the house, could be bank accounts, shares, things like that. But keeping in mind, a lot of the time couples own their bank accounts and property jointly or as joint tenants. So in that case, if one of them pass away, it automatically passes to the survivor, regardless of what your will says. And then only once the survivor's passed away that it would go out under their will. So a lot of the time people don't realize that their super isn't automatically dealt with under their will. So with super, that can sometimes be your second largest asset after the family home, or even your largest asset because of the life insurance component that could be attached to it. With super, generally speaking, the fund trustee gets to choose where your super goes within a limited class of people. So they can pay it to your spouse, they can pay it to your kids, or they can pay it into your estate to be dealt with under your will. But you can usually put a binding nomination in place that takes away the fund trustee's discretion. So it's essentially like the will for your super fund. There are also some different tax consequences that can occur depending on who you leave your super to. So if you leave your super to your spouse or to a dependent child, then usually they receive your super tax-free. If you left your super to a non-dependent child, so someone that, so a child that might have moved out of home, for example, then they could be taxed at up to 17%. But instead, if you left it to that child, to the non-dependent child through your estate instead to be dealt with under your will, then they could be taxed at up to 15%. So a slightly less because there isn't a Medicare levy. So we work with you to achieve the most tax effective outcome for your estate plan. Sometimes, and quite often, people want to leave their assets equally between their children. So in this circumstance, we try to get as much of the super proceeds out to the dependent children who would receive that tax-free, and then the non-dependent children might receive more of the estate assets. So that just means there's going to be more in the pot at the end of the day without some of the money going off in tax. So, and then the last pot is our family trusts. You might have assets in family trusts. So with family trusts, it's all about who controls the family trust. The controller is usually called the appointor or the principal of the trust. Usually their sole job is to choose who the trustee of the trust is. The trustee is the one that gets to choose what happens with the assets. So if the controller doesn't like what the trustee is doing, they can boot out the trustee and put a new person in. So it's quite a powerful role. We usually include a clause in your will that says if you control a trust when you pass away, then this is who takes over control. We do need to check the rules of the trust deed though, to make sure that the actual rules allow you to pass control under your will. If it doesn't, then we just amend the rules to allow for that. So that's why we talk about super and family trusts and not just your will. We have to deal with all 3 assets. And it's our job to tie all of that up into a nice bow to make sure no matter where those assets fall at the end of the day, it will all be dealt with in the same way. So if you were to set up a company, the shares in that company might fall into one of those, would have to fall into one of those trusts, into one of those pots, sorry. and you're going to buy assets, sell assets, move things into super, and eventually move things out. So we draft your estate planning documents so everything will be dealt with in the same way, regardless of which pot they fall into. So we do a lot of work for complex estate planning clients, where they've got second relationships, with farming clients. But we also do work for your standard mum, dad, couple, kids operation. So in that situation, the parents usually want their assets to go to each other first. And then when they've both passed away, they want their assets to go equally between their children. Which is very different to what happens under the rules of intestacy, as you can see here. So another reason to have a will in place. A lot of the time, parents aren't too happy to hear that their kids would receive their assets. The kids would receive their assets as soon as they turn 18 if both parents had passed away. So these days we recommend that you nominate a higher age between 25 and 30, that the kids' share would be held on trust for them until they turn that age. So usually your executor will look after their assets in that time, and they can still use it to pay for school fees, buy holidays, assets for the kids in the meantime. If Sally is responsible enough at 23, then they can choose to hand over their share at that point. If, for example, Toby is a bit hanging out with the wrong people at the time, not very responsible with money, then they can choose to hold it back until he turns that age. So they've got absolute discretion, but then when they do turn the nominated age, it does need to be handed over to them. Sometimes it can be useful to consider having what we call protected trusts for the kids. So they can be useful if a child has a disability or has drug or alcohol related issues. So with protected trusts, someone looks after their share indefinitely on their behalf. When you've got a child that might have drug or alcohol related problems, if they were to receive a large sum of money, it could do them more harm than good. But with these protected trusts, again, if they are recovered, then the executor can choose to hand over that money to them at that point if they wanted to. So usually we like to include a clause that says if something happened to all of the family around about the same time, where would they want their assets to go? So unfortunately, it is a situation that can happen if you're traveling in the same car or in the same plane. We do like to include this clause. A lot of the time, people decide to leave their assets 50-50 to either side of the family, but you can leave your assets however you like. So you can leave it to the cat's home, you can leave it to friends, family members, charities, however you like. Now, if you didn't include that clause in your will and something tragic like that did happen, then your assets would be distributed in accordance with the rules of intestacy. But it all depends on who was deemed to have passed away first. So if the husband was deemed to have passed away first, he leaves all of his assets to his wife. And then when the wife passes away, because she doesn't have any kids that have survived her, then her assets would be distributed in accordance with the intestacy rules. So most likely going off to her siblings. So sometimes, and a lot of the time, people aren't too happy to hear that their assets could end up completely with one side of the family. So it is useful to have this clause in there just to avoid that situation. So we touched a little bit on executors. They're the people that carry out the terms of your will. So quite often people appoint each other first, and then when they've both passed away, they might appoint a family member, friend, or even an accountant can be useful to act as a tiebreaker or as an independent person. The executors are also usually the people that will look after the kids' shares while they're under a particular age. Then we've also got the guardians of the kids while they're under 18. So if something was to happen to both parents while the kids are under 18, we appoint someone to essentially take their place to make any sort of personal decisions for the kids. So it could be about where the kids live, where they go to school, things like that. Now, I find it really useful when you've got kids under 18 to have a separate statement of wishes document that sits with your will. So it's non-binding, but it essentially just sits with your will and provides guidance to the guardians and to the executors about how you want the kids' money to be managed and any wishes you've got for the children's care. So for example, sometimes people say they don't want the kids' assets to be locked away until they turn 25. They still want it to be used to pay for holidays each year, things like that. Then, so that's pretty much the will in a nutshell, so a standard will. You can also choose to include discretionary testamentary trusts in your will. So a little bit of a mouthful. We call them DTTs for short. Essentially, it just allows your beneficiaries to choose to take their share via a trust instead of taking their share into their personal name. If a beneficiary was to take their share personally under a normal standard will, then if they were to invest their inheritance, any income that they earn on that inheritance would be taxed at their normal marginal tax rate, which could be quite high. If instead they receive their share on one of these trusts, they can choose who receives the income from those trusts. So they might decide to allocate income to their spouse who's, for example, a stay-at-home parent, so isn't earning as much, has a lower marginal tax rate, so they could distribute it out to them to save on tax. But more importantly, you can get assets, you can get income out to children, regardless of their age. So if you can imagine you've got a 2-year-old or a 4-year-old, they're not earning any income themselves. So you've got that, that whole, you've got around 18K you can get to those children before it would be while it would be tax-free. So it's absolutely amazing, these trusts, but unfortunately someone needs to die in order for these to come into effect. And you do need them to be, you need these trust provisions to be in your will before you pass away as well. There are some asset protection advantages as well. So if a beneficiary was to receive their share personally, it could just, and they were being sued at the time or going bankrupt, the assets or the inheritance could go into their name and then straight off to creditors. Instead, if they receive their assets on one of these trusts, generally speaking, creditors can't touch what's in a trust. There's also a final sort of family law bonus. And I say it's a bonus only because the family court's powers are so broad. They can take into account the super, family trusts, anything that might have related to the couple. But with this, if you received your inheritance personally, it might go into your marital bank account, joint bank account, and it's just going to get jumbled up, and the courts aren't going to be able to see what's inheritance and what isn't. Instead, if they receive their share on one of these trusts, the inheritance is ring-fenced. You can see exactly what's inheritance and what isn't. There's nothing else in that trust besides the inheritance. So it gives you your best bet at keeping those assets with that beneficiary and not off to the ex. So discretionary testamentary trusts can be very useful, but it does depend on your circumstances and the level of assets involved. So then we always recommend that you have an enduring power of attorney and an advance care directive in place. So these documents deal with who can make decisions on your behalf if you can't at the time. The enduring power of attorney deals with your legal and financial affairs. So who can make decisions about, or who can sign documents on your behalf, who can pay for bills, things like that. We draft it so it's effective immediately, pretty much 99% of the time, which can be really useful. So an example that isn't too useful right now, but hopefully in the not too near future, I had a friend that moved to London to work for a little bit. And as soon as he got off the plane, he realized that his bank account had been hacked into. So he was able to get his attorney back here in Australia to go to the bank for him, and they were able to deal with everything. And my friend was able to go on their merry way. Likewise, if you're lying in a hospital bed and you just need things to keep moving, then the attorneys can do that for you as well. We've also got advanced care directives. So the enduring power of attorney dealt with the legal and financial side. The advanced care directives deals with the medical and personal side of things. So with the advanced care directive, it deals with decisions about life support, if you had to go into care, where you go, things like that. Now there is a section in these forms that we have to use where you can put your binding medical refusals. Now, in our opinion, that's the most important one to have crossed out. It's really hard to come up with all the different alternatives about things that could happen in the future. And if one of your substitute decision makers disagreed with what was in there, they'd potentially have to trot off to court to try and get that part overturned because it is binding. But instead, we like to use the advanced care directives to appoint the people you trust to give legally binding directions to the providers or to whatever company, taking into account what the doctors have said, what they know your wishes to be and the actual circumstances at the time. So that is pretty much everything. So you've got your will, you've got you might have a nomination for your super fund, you've got you might include DTTs in your will, and then you've got your enduring power of attorney and your advance care directive. So that pretty much covers all of the bases. I think just before I finish up, I'll just give you a bit of a background as to how we operate. So normally we like to see clients first to get an idea. So we meet with you first to get an idea about your wishes. Once we know what you want to do, roughly speaking, then we'll send you out a fee quote saying these are the documents we need to prepare and this is how much it will cost. So it's a fixed fee and you've got no nasty surprises. And you've got no obligation to go ahead at that point. So if you didn't want to proceed, which hardly ever happens, then you're not on the hook for that meeting. But if you do want to go ahead, we prepare some drafts. Normally it takes around a week, to get those drafts to you. And once you're happy with everything, we organize to sign them. So I'm just telling you that only because a lot of the time we have clients going, wow, that was quite an easy process. And they're usually, quite surprised at that, and then it's not that complicated. So you can get your estate planning documents in place without too much hassle. So now I'll just answer some questions. So one of the questions, should executors distribute within 6 months? So it's a very interesting question. So a lot of the time, depending on what assets you've got in your estate, you might, when you pass away, you might need to apply for a grant of probate first. So that usually takes a little bit of time. The grant of probate essentially allows the executors to deal with the assets. So if we're talking about real property, so houses and usually shares as well, and depending on how much you've got in your bank account, usually over 50K, you'll need a grant of probate for that as well before the banks will release that money to you. Once you've got the grant of probate, then you can deal with the assets. But the question about whether or not you should distribute within 6 months of a grant of probate is interesting. Generally speaking, we recommend that you shouldn't. You should hold off for 6 months, only because within that 6 months after probate's been granted, if anyone was going to challenge the estate, they could do it then. If you distribute it within the 6 months and then the court found that a different beneficiary was entitled to those assets, then the executors could be personally liable. So then, where do people usually have the will kept? So it can be found in case of sudden deaths of both couple. So we usually recommend that we hold on to the original wills of all of those documents. That just means that they do not get lost. We've got legal obligations to make sure that they do come out at the end of the day, otherwise we would get sued. So someone in our office has the lucky job of checking the death notices all the time. So that, and a lot of the time, especially when you've got an accountant, normally they're the first people that hear about a client death, and then they would let us know as well. So yeah, normally we like to hold on to the original, but we always recommend that you tell your executors, tell the people you've appointed where you're keeping them. So you don't need to tell them what's in the will, but just tell them that where the original is being stored. A lot of the time we also provide you with a copy, and we write on there that the original is stored at MT Lawyers as well. So if anyone picks it up, they also know where to go. So I think that's all we've got for today. So I'll hand you back to Alessandra.
Thank you so much, Amalia. I think there was 1 or 2 more questions that came through, but we have run out of time for today. So we will address those on email to you directly. Thanks for presenting this evening, Amalia. If there are further questions, please send them through and we will get in contact with you directly on email. After the conclusion of the webinar, a survey will pop up. It would be greatly appreciated if you could provide us with feedback. You will also receive a follow-up email tomorrow with a copy of the recording from tonight. Thank you so much for joining us this evening, and we hope you all stay well.